So you think you figured out a way to design around that patent, do you? Not so fast. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. Hey, if you like this content, please do me a favor and like, follow, and share. This will be the first video of a 3-part video series on designing around patents. This is an overview video. In the next 2 videos, I will discuss claim construction and the doctrine of equivalence, respectively, which are 2 key issues which will impact whether any particular design around is, in fact, successful at avoiding infringing a patent claim. In a recent video, I explained that in order to design around a patent claim, you must avoid using at least one element of every independent claim in the patent. Let me say that again. You must avoid using at least one element of every independent claim in the patent. The wording I just used there is super important. I didn't say one element of any independent claim. I said one element of every independent claim must be missing in your product. Now, this may sound simple. It is not. And this is an area where self-help can definitely get you into trouble. If you have an actual infringement issue that is of concern, you should speak to a patent lawyer about it. When you try to design around a patent and you are trying to make sure that you are missing a claim element, let's say the patent claim says A, B, C, you're like, I'm not going to use B, I'm going to use D instead. There's 2 big issues that can impact whether that will work in terms of avoiding infringement. The first is called claim construction, and the second is called the doctrine of equivalence. Claim construction refers to the process of interpreting the meaning of terms or language in patent claims. And you may think you know what a term means because you use it in your work, but I can assure you the legal definition that will be applied in court may be very different from what you believe that term means. And so claim construction is the first thing that can impact whether design around is successful. The second thing is the doctrine of equivalence, which is a doctrine that says if your product is missing a claim element, but it has something else that could be deemed to be substantially similar. They usually say insubstantially dissimilar, I think, in the cases. But if you have something that could be deemed an equivalent, even though it's not literally the same thing, then you will infringe the claim. The law in both of these areas is complex and often unpredictable, and it requires some help to navigate it. And we will discuss both of those issues in the next 2 videos. So please stay tuned. I hope that helps to keep you out of trouble, and I hope to see you here soon.